Good morning, everyone. Let me try that again. Good morning, everyone. Ahora sí. Now we're talking. My name is Marilyn Delorbe Silva, and I serve as a Community Engagement Director here for Miami-Dade College West Campus. And I would like to welcome all of you to our beautiful campus. How many of you are here for the first time? ¿Cuántos de ustedes están? Tegus. Sí. Welcome. Welcome. We're really thrilled to have you. On behalf of our campus president, Dr. Beverly Moore Garcia, we want to welcome you and thank you for attending this interesting event, which is all about legal services. We have a special guest, which is the Cabanas Connection. Did that rest? And they will be leading this event today. And I want to also thank our partner, Doral Family Journal, with Ettore and Sandra, that are our community leaders and have invited all of you today here. Quiero darle la más cordial bienvenida a todos ustedes aquí a Miami-Dade College West Campus. Soy la directora de Relaciones con la Comunidad y en nombre de nuestra presidenta, Dr. Beverly Moore Garcia, nos contenta muchísimo de tenerlos aquí con nosotros. Hoy tenemos un evento muy interesante, todo sobre afectos legales, becas, y estoy seguro que va a ser de gran interés. Así que, y quiero también darle las gracias a nuestro aliado, el Doral Family Journal, Ettore y Sandra, quienes conjuntamente hacemos todos los meses estos eventos para abrir el campus a la comunidad, pero también para educar, para compartir información relevante e importante para todos. Quiero pasarle la palabra antes de nuestros invitados a Ettore Sabatella, que es el editor de Doral Family Journal.
Thank you. Good morning. ¿Qué pasó en este lindo día con este ambiente y con este clima tan fabuloso? Quiero que todos griten buenos días. Good morning. Así es, energy. Bueno, para mí es un honor de verdad estar una vez más aquí en el campus. Gracias a Marilyn, Miami-Dade College, a todos los integrantes, a todos nuestros sponsors, a nuestros clientes, a la firma de abogados que tenemos hoy aquí con un honor y un orgullo bastante grande, que son temas muy importantes, relevantes que nosotros llevamos a nuestra comunidad y de un mensaje por nuestro lado, porque son temas de suma importancia para que cada uno de ustedes puedan tenerlo como parte cultural y aprender un poquito más. Aprendemos todos los. Bueno, sin más quiero agradecer a todos los sponsors, a todos los presentes que están acá y sin más otros preámbulos, quiero dar la bienvenida a nuestro amigo Sebastián, perteneciente aquí a la de la firma de abogados, o papá presente de mi empresa familiar y donde todos pueden tener la asesoría gratuitamente y desarrollar con ellos cualquier tema, cualquier tema que ustedes tengan como importancia legal, que ellos lo puedan asesorar. Muchas gracias a todos.
Bienvenido, muchas gracias, buenos días. Soy el licenciado Sergio Cabañas. Yo soy el dueño de una empresa que se llama Divorce Lawyer. Así que si están buscando un divorcio, ya saben dónde venir. O si se van a casar, también van a tener un acuerdo prenupcial. Así que ya sabe por qué están. Entonces, yo nací en Puerto Rico. So let me say this in English because most of the presentation, Puerto Rican, Boricua. Yes, thank you. So welcome everybody. I want to thank Miami-Dade College and all the sponsors for being here. Wonderful event, very professionally done, and thank you for that. I am Sergio Cabanas. I'm attorney at law. I'm the owner and founder of the Divorce Lawyers. I was just telling everybody, whoever needed a divorce, come see me. Or if you're getting married, a prenup. So it happens. A little bit about myself. I was originally from Puerto Rico. I'm actually Cuban by blood. My entire family came from Cuba. And actually, they came here in the 60s when Castro took over. My father was not welcomed there because he opposed the government at that time. And things did not go well. He lost all of his farms, his properties, as Cuba, the government took everything away from them. But the walk away from that is that he came here as a graduate engineer. So he always told me and my family, no matter what happens, they could take everything away from you except your knowledge and education. So here we are, very fitting to be at a university. And of course, I pursued higher education as did my siblings. They're both physicians. I became an attorney. So we gobbled up education because part of the instilled fear, good fear, paranoia that helped us achieve things in life. But so thank you for being here. And without further ado, todo en acá. Bueno, porque entonces, bueno, simplemente le estaba explicando que soy originalmente de Puerto Rico, pero mi familia todos vinieron de Cuba, eh, donde mi padre en ese tiempo no se llevaba muy bien con el gobierno de Cuba, le quitaron toda la finca, todo lo que tenían. Lo único que le faltaba son un par de aretes de oro que escondió él en el pelo de mi hermana cuando salieron de Cuba. Así que empezó de cero, pero siempre me decía lo importante de tener educación, porque eso sí, el gobierno ni nadie te lo puede quitar, del conocimiento, teniendo educación. Así que yo y mis hermanos nacieron y nos criaron que es bueno tener educación. Me hice abogado, mis dos hermanos se hicieron médicos, así que eso tengo mucha crianza en ese aspecto. Entonces, bueno, por eso es un honor de estar aquí para compartir ese conocimiento, esa educación, para ayudarle en lograr unas cosas o servicios legales que se van a ofrecer aquí entre poco. Y entonces ahora le quisiera yo presentar a mi hijo, Sebastián Cabañas, que es parte de una de esta nacional.
As- Hi, everybody. El español que él es mucho mejor que yo. Perdón in advance. Okay, so today I'm here to talk about the Cabanas connection. So, did you guys know that according to the American Bar Association, a significant portion of the population struggles with understanding their basic legal rights? 60 to 80% of people involved in civil legal matters like housing, family, or debt cases do not have legal representation and often don't understand their rights. Another interesting statistic is a 2021 study's support from the Legal Services Corporation found that 92% of low-income Americans receive inadequate or no legal help for their civil cases. We realized that people are experiencing two main problems. I used to work in the marketing department at his firm, the family law firm, and we realized that people were calling us all the time about things that had nothing to do with family, not divorce, prenups, nothing. They were calling us about immigration, estate planning, criminal, business, you name it, they would call us. So we realized that people were experiencing two main problems when navigating the legal process. Number one, they needed help learning what kind of help they needed in what practice area. For example, we were a divorce law firm. People were calling us about criminal. No, we don't do that. The second thing we realized is that people also needed help finding the correct attorney to help them with that matter as fast as possible. Because sometimes there is a deadline. Like in family law, it takes 20 days once you're served to go find a lawyer, get the money, hire the attorney, and have them file on your behalf to represent you. So it doesn't leave you a lot of time. There's a lot of urgency there. So that's where we came up with the idea, both of us, for the Cabanas Connection Foundation. The Cabanas Connection Foundation is a 501c3 nonprofit organization committed to empowering individuals through free legal education, access to legal support, and scholarships to fund the next generation of attorneys. So how we do that, there's three different things that the Cabanas Connection does. The first one is our legal helpline. We connect individuals with one of our 4 experienced attorney who can assist them with their specific legal needs. So when you call us, we help you go, okay, no, you're not looking for a family lawyer, you're looking for a criminal attorney. And then we will introduce you to 4 criminal attorneys, and then you can meet with them, discuss your issue, figure out who best fits your criteria as a consumer, and move forward with them if you wish. We also host legal education workshops like today's event, where we bring different speakers on different areas of the law to come and educate the public about the different areas of the law. And if you're navigating any, you can come and learn from people who do it all day, every day. And then finally, the last facet we do is our scholarships. We're trying to raise money to fund the next generation of attorneys who are trying to go into law school. And we always think, like, how many people would have become attorneys if the barrier to entry to law school, that amount of cash up front is a lot of money for a lot of people. So how many brilliant people would have become lawyers because that was their passion, but they chose something else because it was more economical. So we're trying to raise money to fund the next generation of attorneys as well. ¿En español?
Entonces, we should know that nearly 7 out of 10 adults, this is an interesting statistic. You're going to learn why in a minute. But 7 out of 10 adults in the US have no will, no formal estate plan. That's 66 to 70% of people either become incapacitated or die without any type of estate plan or will. Now, that's a big deal. And I'll tell you why. Because it affected my family personally, even though I'm a lawyer. So my father, he rest in peace, passed on, and he had an estate, and he had no will, no power of attorney, nothing. So in addition to the grieving process, because we were very close to him, he was a very good man, but the family suffered even more. The chaos, the confusion, and all of the anger and frustration that ensued from that within our family. Contrast that to my aunt, who also learned from this experience, and she had a complete estate plan. When she got sick, her paperwork was all in order. We were able to, specifically me, she named me, the lawyer always has a fun in the pen, and named me as the personal agent for her to take care of her while she was sick. And then, of course, when she passed on, everything was organized. There was peace and harmony in the family to help us get over that grieving process. So this is very important. And there's a lot of lack of knowledge out there of how that can impact our families. So part of our outreach program, which we're doing with our partner here today, is to show you the significance of that legal service for you and your family to consider. Ahora lo digo brevemente en español, de que yo le estaba explicando la estadística que dice que 7 de 10 adultos fallecen sin tener cualquier plan patrimonial, sin testamento ni nada. Y le quiero decir cómo eso puede afectar a la familia y compartí yo una historia personal donde mi propio padre, teniendo un caudal con bienes, etcétera, no tuvo ningún testamento, ningún plan patrimonial, nada. Y eso además de sufrir por el fallecimiento de él, porque mucha gente quería a él mucho, ahí también, además de todo, tuvimos que sufrir con la frustración, la confusión que causó dentro de la familia por él no tener ninguno de los bienes organizados. Así que por eso yo comparé lo que le pasó a mi padre y a nosotros con lo que pasó con mi guía, porque ella también vio lo que ocurrió y ella sí hizo un plan patrimonial, bien todo organizado, todo bien arreglado. Así que cuando ella se enfermó, pudimos arreglar todo, teníamos los documentos en orden para ayudarla y, al fin cuando falleció ya tenía todo planeado, todo organizado y así ayudaba a la familia de sobrevivir y sobrevivir y pasar con la tristeza y tener todo ya bien organizado. Así que los servicios hoy que vamos a hablar aquí es muy importante para mí personalmente y debería ser importante para usted para evitar lo que ocurrió a nosotros también. Without further ado, I'm going to introduce our speaker for today. Her name is Odelia Gober. Odelia is from the law offices of Odelia Gober. And you guessed it, Odelia is an attorney practicing in the world of transactional law, which is real estate closings, uncontested probates, wills and trusts, which is the subject here of today. She's a lover but not a fighter. Those were her words on her website. She's a lover but not a fighter. And Odelia can be stalked on her website, and she takes that as a compliment. And her website is www.ogogerlaw.com, where you could read her blogs about pulp culture, legal disputes, and what we can learn from celebrities and shenanigans. So with that being said, let me present Miss Odelia Gober.
Hi guys, good morning. Thank you for breathing the cold, right? Or the cold at least. I'm Adelia Goldberg. I'm an estate planning lawyer. I'd like to thank everyone for coming out. I'd like to thank Baddest Connection from VITE for thinking of me, little old me, from Miami-Dade College for hosting such a beautiful event. I have to be honest, I didn't know what I was getting into, but I'm pleasantly surprised. Today, we're going to be talking about estate plan, right? And the format of this conversation is going to be, I'm going to talk a little bit and then I'm going to put together a slide, and then I'm going to open it up for the audience. So if you guys have any questions, write them down or keep them in your head. Now, for me, the sign of a good speaker is someone that introduces a new thought, right? Something I had never thought about before. If I'm listening to someone speak and I'm inspired to have a new thought, I'm like, oh, it's a good speaker. So hopefully today, my goal is going to be to teach you a little bit about estate planning and then also inspire and thought. Based on space that we are all doing. So, estate planning. What is estate planning, right? The great question. Sit do the estate planning, it were time to do this refined boy coding. You want our assets to roll directly to the beneficiaries without making a pit stop at the poorhouse. And spoiler alert, believe it or not, is with beneficiary forms. So, at some point, it's going to be very important that everyone is assured to vote in a bank and list a beneficiary. That's the only way to avoid probate. Because if you guys put together a will, that's cool. But the will does not avoid probate. The will just tells the judge what to do if they find yourselves in the probate court. Then, everybody needs a beneficiary for every asset. Now, if your beneficiary is less than 18, that's a minor. Minors cannot have assets that like the table. And we give the table $1 million? No. So if your beneficiary is a minor, or if you've got a bunch of beneficiaries, like more than 5, or if your beneficiaries hate each other, or if your beneficiaries have a problem, right? Somebody has the boyfriend we don't enjoy, or an addiction, or a problem, or like the government benefits, you are a candidate for a trust. Okay? Because a trust is not dependent on the size of the estate. It's this big misconception. People say, well, I don't have enough money for a trust. I'm like, well, not worry about your asset. And the trust is not dependent on the types of asset. A trust is dependent on who your beneficiaries are. Who's going to get your stuff. So again, if your beneficiary is not one or two its own children that's demanding in their affairs, you probably need a trust. And a trust is a really great idea in South Florida because there's no downside to establishing a trust. The only downside, you avoid probate, and we can have additional protections for our kids. Now, the next thing I want to talk about is how we need assets into a trust. Because a trust is kind of like a box. It's not pre-filled with anything. So really, is this okay? Guys hear me? Okay, we're going to do this. So really, what we want to do is establish a Borges trust and then link our assets to the trust on the asset side. So you're going to go to the bank and you're going to list the trust as the beneficiary. You're not going to write in your trust, oh, my checking account is a part of this trust, or my 401k or my real property is a part of this trust, because that's not moving anything into the trust. No, don't do that. What you're going to do is you're going to go asset by asset to link into the trust. Okay. So now that we have the basics, what I'm going to do is I'm going to ask Liani and Shira, Friday, to pass around these blue sheets of paper, and they have some words, legal words, and some descriptors, because estate planning is a language, right? We talk about a power of attorney, we talk about a healthcare policy, we talk about probate, like in all these random words, and unfortunately they apply to all of us because we're all part of this human experience, right? Everybody gotta die. So it makes sense for us to do a little bit of planning now to save a lot of energy later, and it's easily doable. Anyone could put together a plan, okay? So we're going to get some definitions go so you guys can write some terms, write some thoughts. I should have done that in the beginning. The other thing I want to talk about a little bit is the difference between a revocable trust and an irrevocable trust. Because people call me all the time and they're like, which one do I need? Revocable, irrevocable, oh, interchangeable. It's like pitted and unpitted, right? You know, is it the same thing? The difference between a revocable trust and an irrevocable trust is that the revocable trust can be amended. Let's say I do 4 trusts a day that are revocable. I might do 2 irrevocable trusts a year. That's how. Is it me? Is it me? Am I? Is it you? Is it me?
But just keep talking normally. I'm trying to adjust to your life.
Okay. All right, Kitty hosted. So if we do 2 irrevocable trusts a year, that's a lot. That's how uncommon the irrevocable trust is. Because why would you set up a trust that you can never undo? What's the point in that, right? It's kind of counterintuitive. We set up these trusts so that we avoid probate. But if these people turn us off, we want to get them out of our trust. We want to revoke that trust and get rid of the people we no longer enjoy. The idea of an irrevocable trust is typically to avoid estate tax, which is currently set at $15 million per person. So married couple enjoy $30 million of estate tax freedom. So only if you have more than $30 million do you have to deal with estate tax. That's why irrevocable trusts in 2026 are not really a thing. Okay, so everyone in this room should forget about an irrevocable trust unless you have more than 30 million. Okay. So I'm going to start our presentation here because I think the best way to learn is through other people's mistakes. And who best to talk about than famous people, right? Because they make all kinds of mistakes and we can learn from them. So the first one we're going to talk about is in-excess singer Michael Hutchins. And his problem, well, is he passed away. And when he passed away, he had such a complicated estate plan. I mean, trusts and LLCs and more trusts. Testing. Is that better? Worse? The same? Just
Give me a second. I gotta go back.
okay. So I guess he was very concerned. He put together a gorgeous trust. He put together a gorgeous will. And in his will, he left everything, to the people that we kind of expect, his daughter, his people he loved. But for some reason, the estate plan was so complex and so complicated that 8 years later, they still couldn't unravel it. The courts had no idea where the stuff was. He wasn't the beneficiary, he wasn't the trustee, and everything was so convoluted that nobody knew what was going on. And the moral of the story is, yes, there's something as too much estate planning, right? We say, well, you can't go too deep with this, but you really can, right? You can do it into such a level that it no longer makes sense for you. So really, everyone's estate plan is customizable to them, to their goals, to their beneficiaries, and to the way that they kind of enjoy risk in their life, their risk tolerance. Okay? The next celebrity is the sandals owner, Butch. Now, Butch died with billions, with a B, billions of dollars. And he set up a gorgeous trust. And in his trust, he listed his son as the trustee, the successor trustee. His beneficiaries were a bunch of octogenarians, people in their 80s. And the son didn't really want to give them the money. And his brilliant plan was, well, I'm just going to stall the distributions. Each beneficiary was supposed to get 10 to 15 million. And imagine if he kept like 3 of those beneficiaries' funds, he could give it to himself. And that's what he was doing. He was stalling the payouts to these beneficiaries. In fact, 2 of them died after Butch and never got their money. Right? So, of course, the other remaining beneficiaries went to court and we need the son to give us our money. So the lesson is make sure you trust your trustee, right? We want to have that some kind of control in place so that, we assign a trustee that has good ethical judgments, right? And we want survival language to say, should they survive me? Should they not survive me? So what we put in the trust is equally as important as how we fund it. All right, next. We've got Carl Weathers. So he did amazing planning too. He had a trust, he had a will, he funded his trust. Everything was going well. The family was outside of probate for a very long time until one day they discovered a safe deposit box. And in that safe deposit box was money, significant money. We don't want to just sleep on that. So, of course, they had to go to court, they had to open a probate, and we have a specific order to open safe deposit box. In fact, it's 3 orders. We have to have an order to open the box, an order to inventory the box, and then an order to take things out of the box. That's about 1.5 years for me in the probate court. And sometimes when I probate a safe deposit box, there's nothing in it. Oh, do you know how annoying that is for someone like me? I'm like, what's in it? What's in it? Nothing but it. Or, God forbid, there's now a will in there. All these years we thought there is no will. We open the box. In the box is a will. Do you know how much work that is for me administratively? Now I got to go back to the judge and say, oh, Your Honor, we messed up. There's a will. Very annoying. So the lesson is do not put your very important papers in your safety deposit box. It's such an important lesson that while we're executing the documents, I say, let's talk about where you're going to keep your documents. And I make my clients tell me where they're going to keep their documents. And I'm going to say about half say, well, we really should get a safe deposit box. And I got to say, don't do that. Do not put these In fact, you know how movers hate glass? Estate plan lawyers hate safe deposit boxes for this reason. So if you have to have a safety deposit box, that's okay. Do not put your very important papers in there. We want these documents to be available in the event of an emergency. Where can we find them? Here, in the drawer, in the cabinet. If somebody breaks into your house, they do not want your estate planning documents. I don't know what they want, but it's not this. You don't have to worry about it. No one's going to take them. Okay? Moving on. Richard Simmons. I grew up in the 80s. I'm old. I remember this guy. He was great. He inspired me. Anyway, he had great estate plan too. He had wills. He had trusts. Now, his mistake is that he named his housekeeper and his brother as the trustees of the trust. And the housekeeper felt intimidated, or I'm maybe presuming, but she gave up her right as the trustee. She was like, you know what? I don't know what's going on. I'm not really an English native. Can't imagine. I don't even really understand what a trust is. So right away, she gave up her power as the trustee. And then someone told her, but the trustees get paid. Why'd you do that? You gave up your power. And she's like, oh my God, I didn't know what I was signing. And now she went to court looking to be the trustee again. Okay. So the lesson with Richard Simmons is you got to think about who your trustees are. You may even want to have a conversation with them. Listen, I'm going to name you as a trustee. This is a lawyer to talk to in the event that you become a trustee so that you could get some legal advice, things along that. Because if there's a big power dynamic, you want to kind of pay attention to that. Okay? Moving along to Thomas Jefferson. He was a founding father. Amazing. Now, part of the problem with his estate plan is that he had a lot of debt. He wasn't very good financially. He just borrowed, spent, and borrowed and spent to where he died. He had a huge debt. He left nothing to his beneficiaries. And the problem with that is that he didn't really list beneficiaries. What he did is everything kind of went through the probate process so all the creditors could attach. Because if you die with debt, but you have beneficiaries, then you don't have an estate for the creditors to attach to. So if you've got $1 million in the bank and you don't list the beneficiary and that $1 million has to go through probate, through the will to your beneficiaries, there's an opportunity for the creditors and the IRS to come forward. So if you're hearing me right, probate is not only expensive and time-consuming, but it subjects us to creditors and the IRS who we don't mess with. Okay? So had he had a great estate plan with beneficiaries, then his creditors may not have anywhere to go and his beneficiaries may have gotten something. Maybe. This guy. This guy loved his gardener so much that he wanted to make his gardener his primary beneficiary. He was old and he had a bunch of billions. But the problem was, many years ago, he kind of gifted his estate to a nonprofit. He made some kind of weird agreement, like an heir agreement or something. We don't even have that in Florida, but he did. He signed over his entire estate to someone else. And then decided, but I love my gardener so much that I want to adopt him. I think that him and the gardener were roughly the same age, but he wanted to adopt him so that the gardener could be his heir, so that the gardener would inherit his estate. Because in wherever he's at, you can't disinherit your child. Here in Florida, you could disinherit anyone except for a spouse. But in some countries, most Latin countries, you must leave something to your children. You cannot disinherit your children, no matter how terrible they are. But in America, you can disinherit your children. Make no mistake about it. I do it all day long. So, what do we learn from this guy? We learn that in your estate plan, if we have adoption language, what we say is adopting anyone under the age of 18. We also learned that you can, in some jurisdictions, make a contract for your estate in advance. But we also want to be mindful what we put in our estate planning documents, right? Make it make sense, folks. This guy, he was great. He was smart. He wrote his own will. What do we think about that, right? AI could write my will. AI could write my trust. What do I need a lawyer for? Save a couple $1,000s. Do it myself. Don't do that. Do you know why? Because there's nothing worse than a bad will. Because now I got to clean it up for you. You know, you think you're saving money, but you're not. These people are going to call me to clean it up. All the online documents are missing one very important piece in their last will. And I don't know why they do this, but they do. In Florida, in the last will, somewhere in the last will, we have to say that the person who executed the will, the executor or the executrix, were of sound mind. And they don't have that. I don't know why. So I do see these wills. They come across my desk all the time, and I got to clean them up for you. I got to call out all the witnesses. I got to get affidavits. I need hearings with the judge just to make your will valid. So don't write your own will, right? Like filling your own cavity. Can you do it? Yes. Should you do it? No. So this guy wrote his own will. And of course, he had a very, very simple will because he's a man of a few words. And in his will, he forgot the entire power section. Now, most documents have a power section because how are we going to empower these people to act, right? Everybody needs power because without power, you're naming someone, but you're not giving them any power. But it's a very long and annoying section. In fact, a percentage of my clients, when I sent them their drafts, they start editing my documents and they cross out all the powers. They're like, well, you know, I put in a power to run a business. They're like, I don't own a business. I put in power for farm equipment. They're like, there's no farm equipment. I don't have investments. And I'm like, listen, people, we need the powers. That, hey, it's better to have them in than to not have them because there's no harm in having them. We're like, I don't know, just making sure, just in case we need this power, we haven't. Why not? What's the point? Ink is free. It's going to be fine, right? So don't write your own will and definitely don't edit your lawyer's wills. Okay? All right. So what I want to do is I'm going to open it up. If you guys have any questions, if I, kind of muddled something that you thought you knew that now you don't know if you know, now's an opportunity. Of course, you can also visit my table and give me a call if, public forum, public speaking isn't a good thing. Are we doing okay on time? Oh. All right. Anybody have any questions for me?
Yeah, I have to question. In a family trust, the grantor can be the trustee?
In a family trust, can the grantor be the trustee? That's a good question. Yes. In my grantor revocable trust that I'm probably going to draft for all of you, you are going to be the grantor, you are going to be the trustee, and you are going to be the primary beneficiary. The trust is for you. You are all three. And this way, when I move your real property into your grantor revocable trust, I tell the county it's a transfer from you to you. So there's not going to be any doc stamps, no transfer fees, no property reassessment, and you keep all your homestead goodies.
But the second part is so it when the grantor die, who executes the trust or the heirs?
So that's a good question. When the grantor dies, the trust becomes irrevocable. There is no more grantor and the trust can no longer be amended. But we do have a backup trustee, a backup manager, and a backup beneficiary, right? So the trust could be managed by the trustee. They can sell a property, distribute funds, deal with your expenses. But we no longer have another grantor. Only one grantor, and that's you.
Okay, so when we establish the family trust, then we determine who is going to be the trustee when the grantor dies. That's exactly right. We have to find.
Oh, yeah. You're going to tell me one backup trustee and then another backup trustee because we always have backups to our backups, right? Very good. Any other questions? Yes. You already got the trust. You need to do this ladybird. That's a great question. If you already have a trust, do you need a ladybird deed? I love a good ladybird deed discussion. I could talk about ladybird deeds for days, right? I'm not going to bore you, but they're a great tool in South Florida. Not all states have a ladybird deed. Florida is one of them. The idea of a ladybird deed is its type of ownership. It's on the deed itself, and the deed would say that the property goes from you to you for life with a remainder interest in the trust or a remainder interest in humans, right? Because remember, we have to fund a trust, right? We have a trust. Amazing. Everybody clap. But now we got to link our assets to it. So the way we link a property to a trust is with a deed. Now we could either draft a deed to move the property in the trust. So who owns your property? Not you, your trust. Or we could do a ladybird deed into trust. Who owns your property? You. Only when you pass away does the property go into the trust. That's the difference between moving the property into the trust right now and doing a ladybird deed so the property goes into the trust after your passing. Why would we do it a little bit after the passing? Because I'm fancy and it's fancier and I like to be fancy. That's all. There's no downside. There's no benefit. There's no difference.
I'm sorry. And about the POD designation on the bank accounts, if all the accounts are in the trust name, you don't need to do that.
That's exactly right. So the idea was you can have a payable on death, right? POD into the trust, or you could retitle the assets in the name of the trust. They both do the same thing. They both fund the trust. That's exactly right.
I like you. Good morning. I may have missed this, so you apologize. Do we need a trust before the labor? Uh, ooh, this is a little bit loud, but I do love the microphone in pink. Do I need a trust? Yeah, okay. Do I need a trust for me to do a ladybird?
So I don't know. I don't know enough about you to know. Some people need a trust. Some people need a ladybird deed. Some people need a ladybird deed into trust. I talk about it so much that not only did I make videos, I made cartoons. So some people like a cartoon. So if you go on my website, I made a cartoon about what is a trust, what is a ladybird deed, and how the ladybird deed and the trust work together. But really, it depends on who your beneficiaries are, right? If your beneficiaries are minors, you probably need a trust. If your beneficiary is, adult, then you may not. Now, the downside of adding a human on a ladybird deed, not a trust, but making the property go from you to you for life with the remainder interest in another human is that, let's say the person you added, as we call them remainderment. When you pass away, that person gets your stuff, the remainderment. Let's say your remainderment gets in trouble with the IRS and only the IRS. Then the IRS could put a lien on your properties while you're alive. So we have to be mindful who you add to the deed as a remainderment, which is why sometimes we create a trust and we move the property into the trust after passing versus to another human that could affect our property.
Okay. Thank you.
Any other questions? We're all estate planning masters today. All right. How did I do on time? Great. Amazing. So if you could, there is one question we have.
With that, if you're taking your property into the trust and you name somebody to get the property afterwards, and then you change your mind, how do you facilitate that?
That's a great question. I'm assuming it's a revocable trust. A revocable trust is amended through an amendment. Now, if we ever want to do a new will or new power of attorney, we just rip it up and do a new one. But if we're changing a trust, we don't rip it up into a new one because the trust is kind of like a thing, right? It's got assets. It's been funded, hopefully. So we don't rip it up and do a new one. We would amend it with an amendment. First amendment, second amendment, third amendment. If your changes are too long, then we would do a full restatement. We keep the name and we just restate the whole darn thing. Because the trust is like a box, right? And changing the trust is like painting it. But it's still the box. Still has the box name, still has the stuff inside the box. We're just painting the box by amending it. Yeah.
Oh, sorry. So if we have assets in the trust and we want to do LLC for each one of them, then we will do an amended and we don't have to change the trust.
So if we have a trust and we want to do an LLC, we have a little bit of a conflict because either the asset could be in the trust or in the LLC. It can't be in both. We can create a trust to be the trustee of the LLC, or we can create an LLC where the trust is a member of the LLC. So the trust and the LLCs can work together, but the asset is only in one. It's either in the trust or in the LLC. Can't be in both. It could be if the trust, if the asset is in the trust, the LLC could be the trustee. If the asset is in the LLC, the trust could be a member. That's how it works. But the asset could only be in one at a time.
Okay. Oh, yeah. The main question was, if we have the asset in the trust and we want to move those assets for in an LLC, each one of them, let's say because they are rental properties, then we can do that after we create the trust and then we do an amendment on the trust.
So if we take a real property, like a house or a building, and move it into an LLC, you're making a mistake every time because assets in an LLC do not avoid probate, number one. Number two, moving real property in and out of an LLC incurs dock stamps, transfer fees, and the county will reappraise the property. You can never claim homestead in an LLC. There's a lot of negative downsides to moving real property into an LLC. It's not encouraged, according to me. You can ask other people and they might have another opinion, but in my humble opinion, it's never a good idea to put real property into an LLC.
Good morning. I'd like to ask it just the deed can be changed with a different percentage, leaving all the trust and beneficiary the same, but percentage of D and having that recorded. Is that adequate?
So I think you're asking, can a property go 50% to a trust and 50% to a human? Like that? Is that the question?
If there's two persons as the beneficiary, and one person decided, you've done all the work and you can have a bigger percentage. Not you, but a fair extra percentage. And it's written with a new deed. Is that valid and adequate?
Yes,
It could be.
it could be.
With the consent written by the original beneficiary that I accept and agree that the other person should have bigger percent.
I think what you're talking about is once the person passes away, can the heirs agree to change how they get stuff?
Prior to the person passing.
No, not prior. Before the person passes away, they're the boss. They control what happens. But after they pass away, the beneficiaries can get together and say, I don't want it. You deserve more or, whatever. But while you're alive, you're still the boss. So they can agree, but you can get them out of there, right? How are we doing on time? We're doing what? Very good. Well, I'd like to take an opportunity to ask the audience, have I inspired any you thought? Have we had, sorry about that.
In regards to that, again, okay, you've passed. Yeah, got your successor trustee, and they get together and they say, "Well, I'm gonna do this." Yeah. Then, of course, you're dead. You had no recourse, but it's so they can really the successor trustees could do anything they want to.
Not unless all the beneficiary agrees. Okay. If everyone agrees, then yes, they could amend your irrevocable.
But if one person doesn't agree, then what happens is
They have to follow your turn. If everyone agrees, we can amend a trust.
or it needs from court.
Or so they go to format. Pass it back to back. Okay. How did we do on our independent thought journey? Anyone here have an independent thought? If you have any questions, I'm over there. Feel free to give me a call. We could talk a little bit more about your specific situations. And thank you so much for inviting me. I really appreciate it.
Hello. Ooh, I'm loud. Hello, everyone. Okay, so for those of you guys, so Attorney Odelia will be taking. If you have any personal questions, she will be doing pre-consultations over there in English. If you don't have the time, she has the Spanish attorney not here, but you can make an appointment. Para los que no entendieron, la abogada habla inglés. Si quieren consultar con ella gratis, lo pueden hacer aquí. Si lo quieren hacer en su oficina, y tiene abogados que hablan español. También tenemos otro abogado en esquina que le puede colaborar con las preguntas que tengan al final. Pero si quieren algo de estate planning, ella también se lo fue. Si no tienen el tiempo, como les dije, pueden dejar su número y después otro día pueden hablar con él. ¿Any question?
Yo quiero más información de las becas.
Okay. So, this is Sebastián. No, in case. So, quiero decir lo que en The Cabanas Connection. La Cabana Connection es una fundación legal. So, si alguien aquí tiene un problema legal por cualquier tipo de problemas, los llaman y nosotros te contactamos con un abogado. Lo que nosotros hacemos es, con las fundaciones que nos dan, nosotros damos becas a estudiantes que quieren ser abogados pero que no pueden. Ahorita hay muchos estudiantes que son muy inteligentes, pero que no tienen la capacidad financiera para ser abogado. So, nosotros lo ayudamos con esto. Y esta es la fundación que nosotros tenemos, que es The Cabana Connector. So, por eso ponemos estos eventos. Ustedes se educan de cosas legales y con el dinero que colectamos, eso se lo damos a estudiantes. The scholarships? So the scholarships really vary. Sometimes we cover the LSATs. And that sounds depending on the student that we get, we cover either the full fee or we'll cover the first fee. But one of the requirements too at the scholarship is that they have to volunteer. So we're trying to train these attorneys to come and volunteer their time to talk to the people that they care for, right? So it's not just like, oh, you're going to get free scholarship and you're to become an attorney and charge everybody all this money. No, so they have to be involved with the community in order to their scholarships.